In my last video, I started telling you a little bit about a different case study, and this what this next series is about. It's what the person we'll call Blake, right? I never use people's real names. I am a lawyer, and I do acknowledge that people have a right to their confidentiality. It's one of my ethical obligations as well. So, but with Blake's case, she originally had called me because she felt she was being sexually harassed and discriminated against at work. And as we had further discussions, I discovered that it was also a situation where she had been misclassified as an employee when she was really an independent contractor. That's a little different from what we usually expect when we're talking about worker misclassification. I'm Nancy Schick of 30-year conflict resolution, where I resolve workplace disputes like worker misclassification. Sometimes it means that I'm resolving penalties for employers who get it wrong. But in Blake's case, it was unexpected for a variety of reasons. I wasn't expecting a sexual harassment and discrimination case to turn into worker misclassification. The sexual harassment and discrimination was pretty blatant. Unfortunately, not that uncommon in the industry she was working in. We're still working on that and trying to transform that industry. But when she reported it to HR, again, this is an employee. She went to HR and reported this conduct, and they kind of had the attitude of not really our problem, right? They felt like she was suddenly an independent contractor, and they started treating her that way. And this was before the law changed in New York, where we now extend that sexual harassment protection to independent contractors as well. Then she was getting we had to look at things like, well, wait a minute, they're treating you like an independent contractor, but they're giving you a paycheck. You're getting a W-2 at the end of the year. She's been there for quite a while. She was getting health insurance benefits and other types of benefits. So she had a lot of things that suggested she was an employee. But there were other things that suggested she was actually an independent contractor. So why might they decide to classify her as an employee, right? Because they would have saved on a lot of those processing fees, health insurance, et cetera. And it was because Blake came to that particular organization with some pretty valuable intellectual property. They wanted her to be an employee so that they could try to claim that it was a work for hire that they owned. So I unraveled that for her. And not only did we set her up in the correct classification, in the next video, I'll explain what we did with her intellectual property and how we got her an even better deal. Now, I've done several videos explaining the difference between an employee and an independent contractor and talking a lot about worker misclassification. So just go to the playlist for worker misclassification. You'll see lots of it there. If you want to know how we've resolved her intellectual property issues, click that button below, subscribe. And if you have an issue like this that you want to do a consultation, I'll put a link in the notes to the video for that. In the meantime, of course, keep listening with your third ear. For those hurts you can heal.